Okay, any changes to the agenda? Public comment? Number 5 will be open meeting law training. Go ahead.
Kansas. And I'm Deputy Secretary of State, Lauren Hibbert. And I'm Jenny Preston, Secretary of State's General Counsel and Director of Municipal Assistance. Transparency is an essential element of an open and democratic government. In Vermont, our open meeting law ensures that meetings of governmental bodies remain accessible to the public. This accessibility creates a foundation for public trust and participation, which in turn makes government more effective. The open meeting law declares that meetings of governmental public bodies must always be open to the public, with rare exceptions. The law empowers members of the public to play an essential role as an active participant in government and as a check on it. The Vermont legislature updated the open meeting law in recent years to recognize that electronic access to public meetings can improve accessibility, strengthen civic engagement, and support transparent, efficient governmental decision-making. In this video, we'll cover the basics of what you need to know about Vermont's open meeting law. As we dive into the details, please keep in mind that other laws also govern public meetings, like public accommodations laws and other anti-discrimination protections, as well as any requirements for your specific type of public body or set forth in your own municipality's governance charter. And remember, the Secretary of State's office provides education.
Oh, it does. Just up at the down bottom to the right.
On the Secretary of
to the
State
right.
To show what we know about the law.
It's not
to highlight.
Oh, right here.
Okay, yeah, 4 is good.
And to point you to reliable resources for additional help.
Oh, right there.
If you need legal advice about how to proceed in a specific scenario, we always recommend consulting with your own public body's legal counsel or private. When in doubt, focus on the intent of the law. Provide for transparency and accountability in government.
Do you want to rewind like
By
30
requiring
seconds?
public bodies to come to consensus in decision-making before the public and with participation accessible to all. That's the spirit behind all the details. To make for transparent and accessible meetings of governmental bodies, remain accessible to the public. This accessibility creates a foundation for public trust and participation, which in turn makes government more effective. The open meeting law declares that meetings of governmental public bodies must always be open to the public, with rare exceptions. The law empowers members of the public to play an essential role as an active participant in government and as a check on it. The Vermont legislature updated the open meeting law in recent years to recognize that electronic access to public meetings can improve accessibility, strengthen civic engagement, and support transparent, efficient governmental decision-making. In this video, we'll cover the basics of what you need to know about Vermont's open meeting law. As we dive into the details, please keep in mind that other laws also govern public meetings, like public accommodations laws and other anti-discrimination protections, as well as any requirements for your specific type of public body or set forth in your own municipality's governance charter. And remember, the Secretary of State's office provides education, not legal advice. You can rely on the Secretary of State to share what we know about the law, to highlight any changes or gray areas, and to point you to reliable resources for additional help. If you need legal advice about how to proceed in a specific scenario, we always recommend consulting with your own public body's legal counsel or private. When in doubt, focus on the intent of the law. Provide for transparency and accountability in government by requiring public bodies to come to consensus in decision-making before the public and with participation accessible to all. That's the spirit behind all the details. To make for transparent and accessible meetings of governmental bodies, the Vermont legislature put some key rules in place. You can read these rules for yourself by taking a look at the Vermont statutes Title I, sections 310 through 314. You can find the statutes on the Vermont legislature's website and the green law books in your town clerk's office. Broadly speaking, the open meeting law requires that public bodies conduct their business before the public. Under open meeting law, public bodies must provide advance public notice of their meetings, including meeting agendas, allow the public to attend and participate in meetings, whether the meeting is conducted in person, remotely via electronic means, or in a hybrid fashion. Discuss all business and take all actions in open meeting unless an exception in statute applies. keep a publicly available record of their meetings, including meeting minutes, and for some public bodies, an electronic recording posted online. In addition, annual open meeting law training is obligatory for some public body members. Public bodies with websites must post information online about how to file a written complaint of open meeting law violation, and all public bodies must respond publicly to any such complaints. The open meeting law applies to public bodies. A public body means any state or municipal board, council, or commission, including all their committees and subcommittees of those bodies. The open meeting law requires public notice, public discussion and decision-making, public participation, and written minutes from every public body each time it meets. At the local level, public body includes select boards, school boards, planning commissions, and developmental review boards, boards of civil authority and abatement, boards of auditors and listers, municipal public library board of trustees, cemetery commissions, and various other governmental bodies referenced in state statute or by municipalities' charter. Public body also includes any committee or subcommittee that's created or empowered by a public body to do that body's work, no matter its size or membership. That said, the open meeting law does not apply to individual officers in their work, nor does it generally apply to nonprofit corporations or other private boards unless otherwise specified in their governance documents or as a condition of an appropriation, grant, or contract. And while the open meeting law applies to all public bodies, the law does not always treat all bodies the same. The open meeting law sometimes distinguishes between state public bodies and municipal public bodies. The open meeting law also loosens some requirements for advisory bodies. Advisory bodies are defined as public bodies that have no supervision, control, or jurisdiction over legislative, quasi-judicial, tax, or budgetary matters. Advisory bodies do just that. They advise. They have no statutory authority to make final decisions about those types of questions. If a public body does have final authority over any legislative, quasi-judicial, tax, or budgetary decision, then it is a decision-making body, not an advisory one. We will address when being an advisory public body might be relevant later in this presentation. For now, we'll just note that it can sometimes be tricky to tell the difference. So if you're unsure, you should either use the default, more stringent rules for public bodies with decision-making control, or consult your legal counsel.
The open meeting law's requirements are triggered any time a quorum of a public body holds a meeting, that is, gathers to discuss its business or to take action. A quorum is usually the majority of the entire body's membership, and this law outside the open meeting law requires otherwise. Calculate the majority, start by counting seats, not heads. Even if seats are filled, they count towards quorum. For example, a 15-member board, even if several seats are vacant, would need 8 members present to make a quorum. Business means the public body's government functions, including any matters over which the body has supervision, control, jurisdiction, or advisory power. Note that meetings can occur regardless of the member's physical location. We'll discuss remote and hybrid meetings later. For example, if a majority of members find themselves together at a social function, we must take care not to discuss the body's business. The open meeting law might also be triggered by a discussion of business involving a quorum that occurs asynchronously or over time. A string of emails or social media posts could be considered a meeting depending on the circumstances. We'll discuss electronic communication in greater detail later in this presentation. So, do all gatherings of a quorum count as meetings? No, not every interaction involving a quorum of public body members is considered a meeting for the open meeting law's purposes. Here are 3 common examples of gatherings that may occur without triggering the open meeting law's requirements. Communications made to schedule a meeting, organize an agenda, or distribute materials to discuss at a future meeting are not considered a meeting under the law, provided that no other business of the public body is discussed or conducted. These types of communications are, however, subject to Vermont's Public Records Act, and so any record of them must be made available to the public on request, unless an explicit exemption in statute applies. Occasions when a quorum of a public body attends social gatherings, conventions, training programs, press conferences, media events, or otherwise gathers are also not considered meetings under the open meeting law, provided that the public body does not discuss specific business that, at the time of the exchange, participating members expect to be taken up as business of public body at a later time. And a gathering of a quorum of a public body at a duly warned meeting of another different public body is not a meeting for the open meeting law's purposes, provided that the attending public body does not take any action on its business. There are also assorted other carve-outs from the definition of meeting that might apply to the work of certain boards at certain times. For example, site inspections for tax assessments or abatements, routine day-to-day administrative matters that do not require action by the public body and that do not involve money being appropriated, spent, or encumbered, and bilateral collective bargaining negotiations between a school board negotiating committee, the labor union.
Now we'd like to say a word about electronic communication and public meetings. Beyond the carve-outs from the definition of meeting we just discussed, and the protocols for remote and hybrid meetings we'll discuss in a bit, the open meeting law doesn't explicitly address the appropriate use of electronic communication tools by public body members. Given that, here is our general guidance on using electronic communications in light of the open meeting law's language and purpose. Group emails. Group emails do not necessarily violate the open meeting law, but it's best to proceed with caution. Group emails should generally not be used by a quorum of the public body to discuss the body's business. If a quorum is part of a group email and any dialogue occurs addressing business matters, this discussion could amount to an unwarned meeting that triggers the law's notice and public participation requirements. Essentially, a business discussion, and therefore a meeting, can occur as soon as you hit reply all. Document sharing platforms. Like group email, we recommend that a quorum of a public body should generally not participate collaboratively editing a document outside of a public meeting. Collaborative editing, even if performed by members individually and over time, may well fall within the definition of meeting when an exchange of ideas and opinions occurs. This is so even if the work in progress is made public due to the law's notice and public participation requirements. One acceptable alternative is to name a point person who collects and compiles each member's edits and comments for later discussion in an open meeting. Social media use. Use of social media by a quorum also requires caution. This is especially so if membership in the group is closed. For example, only town residents may join, but participation by a quorum in an entirely open group that discusses the body's business could also be problematic. There are certain accessibility and transparency benefits to being available to the public via social media sites. That said, members of public bodies must avoid gathering to discuss business when the time and place has not been announced in advance or is not accessible to all. If you're not sure whether using electronic communication is appropriate, it can help to focus on the law's purpose: transparency, accessibility, and accountability. We always recommend consulting with your own legal counsel if you have a question about a specific scenario. We've covered who must comply with open meeting law and when, and now we'll dig into what a public body must do when it holds a meeting. First up, notice and agendas.
For the purposes of public notice under the open meeting law, there are three types of meetings: regular, special, and emergency. The open meeting law establishes different notice and agenda requirements for each type of meeting. A regular meeting is just that, a meeting you have scheduled to occur weekly, bi-weekly, or monthly on a regular basis at a designated location, usually via a publicly available annual resolution that states the time and place. For regular meetings, you do not need to provide additional notice before each meeting, provided the schedule has already been clearly designated. You do need to post the agenda online at least 48 hours before the meeting if your public body maintains or has a designated website. Municipal public bodies must also post an agenda for each regular meeting at least 48 hours in advance, in or near the municipal office and in 2 other designated public places in the municipality or a neighboring municipality. A special meeting is a meeting held outside of your regular meeting schedule. For special meetings, the time frame for posting notice and agenda is 24 hours. The body must also give notice of the meeting's time, place, and purpose to a newspaper or radio station serving the area, as well as to any person who's asked to be notified of a special meeting, and to each member of the public body, unless a member has waived that notice. An emergency meeting is held only in the event of a true emergency, when it is necessary to respond to an unforeseen occurrence or condition requiring immediate attention. For emergency meetings, the law only requires some notice as soon as possible. Focus here on the open meetings law's purpose, transparency, accessibility, and accountability. If you can manage 24 hours notice, then we recommend conducting a special meeting, not an emergency one.
All regular and special meetings require an agenda. What should be included? Start with the date, time, and location of the meeting. If your meeting will occur via an electronic meeting platform, include info that allows the public to directly access that platform. The open meeting law requires that an agenda must contain sufficient details concerning specific matters to be discussed by the public body. It can be helpful to identify on the agenda any likely executive session. Note that if you list an executive session, more on those soon, on the agenda, it must be identified as a proposed executive session. Indicate the nature of the session's success. If you anticipate that the public body will be voting on a specific matter during the meeting, it is best practice to note the potential vote on the agenda. Additionally, we recommend including on the agenda any key accessibility features of the physical space and electronic platform where the meeting will be held, as well as a contact for questions and accommodations requests. What if you need to change the agenda after it is posted? The open meeting law allows public bodies to add or remove an agenda item as the first act of business. That said, outside of emergencies, we recommend that you avoid adding last-minute agenda items, especially action items, after the posting deadlines have passed. Adding the new item to the agenda for the next regular meeting, or calling a special meeting if necessary, is the better practice here.
As you plan your agenda, you'll need to think about where you'll be holding your meeting. Will you designate a physical meeting location, an electronic platform, or both? Even before the open meeting law was updated to address remote public participation, the law allowed members of a public body to join and participate in meetings remotely. Specifically, the open meeting law expressly permits one or more members of a public body to attend and fully participate in public meetings electronically from a remote location under certain parameters. Each member who attends remotely must self-identify at the start of the meeting. Each member who attends remotely must be able to hear and be heard throughout the meeting. And any vote that is not unanimous must be taken by roll call. Proxy voting and voting by email is not permitted. If a quorum or more of the body is attending the meeting remotely, then generally it must designate a physical location that will be staffed and available for the public to attend and participate in that meeting. We'll address exceptions to this physical location requirement for advisory bodies and in emergency scenarios in just a bit. Beyond these specific requirements that apply when a public body member participates remotely, the open meeting law contains a broader requirement for public meeting locations that differentiate between decision-making bodies and advisory public bodies, as well as state and local ones. We'll go over the broad requirements first and then address some exceptions. State public bodies with decision-making powers must conduct regular and special meetings as hybrid. This means that the body must designate a physical location where the public can attend and participate, and an electronic platform for members of the public to directly access and participate in the meeting remotely, including telephone access. As we've mentioned, the meeting agenda or notice must include information about how the public may directly access the meeting remotely. Local public bodies with decision-making powers must provide a designated staffed physical location where the public may attend and participate for every regular and special meeting. Local public bodies may usually choose whether additionally offer remote access to members of the public. Advisory bodies, whether state or local, may choose to conduct remote-only meetings. As a reminder, advisory public bodies do not have any final decision-making authority over legislative, tax, budgetary, or quasi-judicial matters. Providing a physical meeting location is typically optional for advisory bodies. If an advisory body holds a remote-only meeting without a physical location, it must use an electronic platform that allows for direct public access and participation, including a telephone option. The meeting agenda or notice must include information that allows for direct access by the public. We'll emphasize here that hybrid meetings are always permissible for public bodies. Well-run hybrid meetings are generally considered the gold standard for accessibility. And we'll now summarize some important exceptions to these location requirements for emergencies and localized incidents, and when someone requests alternative access.
When a public body calls an emergency meeting under the open meeting law, that emergency meeting may be conducted as remote only, without a designated staffed physical location. This is true for any state or local public body. When the governor declares a state of emergency, any affected public body may hold remote-only meetings during that time. You must provide notice to the public about the changes due to a state of emergency in the same way you would warn a special meeting. And when a local incident impedes a public body's ability to hold a meeting in its usual fashion, any affected public body may conduct meetings as either remote only or in person only, as it makes sense according to the conditions. Local incidents are situations where the normal way a public body would meet is obstructed to the point where it wouldn't be feasible. This could look like a serious weather event, loss of power, a public health or safety emergency, or received threat to the member of the public. The key here is that the problem directly impedes the ability of the body to meet in its usual in-person or electronic location. If this occurs, the highest ranking officer of the public body may change how the body meets by making a formal written finding and an announcement of the local incident, including the basis of the finding. These written findings must be permanently retained. As with the meetings held under a declared state of emergency, the public body should also warn in the meeting as it would a special meeting, except that some physical postings, those not in or near the clerk's office, may be replaced with postings in a publicly accessible and designated electronic location.
Another exception that open meeting law carves out for the normal location requirements has to do with accessibility. When we say accessibility in this context, we mean removing barriers that people might face in taking part in a meeting. A barrier might look like a meeting scheduled during working hours, a building not easily entered by wheelchair, a room with poor acoustics or bad lighting. Part of the open meeting law is about having meeting locations, platforms, and procedures in place that create good conditions for accessibility. And federal and state laws outside the open meeting law establish baseline requirements to protect people from unlawful discrimination places public accommodation, including meetings of state and local government. In instances where barriers to participation remain, requests for access under the open meeting law the open meeting law allows any resident of public body's jurisdiction, a member of the public body itself, or a member of the press to request alternate access to a regular meeting. A request for access must be submitted in writing to the public body at least 2 business days before the meeting and specify what type of access is being sought. For example, electronic access to an in-person meeting, or that a physical location be established for a meeting that is typically remote only. It's important to include contact information in the written request for access. And this is also important. A requester does not need to provide any basis for their request. If your public body receives a request for access to a regular meeting, you must generally honor it. There are some exceptions here. Requests for access are limited to the next regular meeting, not a series of meetings, nor a special or emergency meeting. And a public body does not have to grant a request for access during a declared state of emergency or local incident, or in the case of municipal public bodies, where the public body shows that compliance would impose undue hardship. Undue hardship means that providing the requested access or required significant difficulty or expense to the municipality to which public body belongs, considering factors such as overall size, availability of necessary personnel and staff, available resources, and the costs associated with compliance. The burden of proving undue hardship is on the municipality. Best practice here would usually be to have the municipality's legislative body take up a question in open meeting, hear relevant supporting evidence, and document a finding in minutes. We recommend any public body considering claiming an undue hardship exception consult legal counsel.
Now we will cover public discussion and decision-making and some exceptions. A key element of the open meeting law is that public bodies must conduct all business discussions and make all decisions in a duly warned open meeting before the public. May a quorum of a public body ever meet privately to discuss business? Yes, but rarely. In two distinct situations, the open meeting law recognizes that private discussions about substantive business may be advisable: deliberative sessions and executive sessions. A deliberative session occurs only when a public body holds a quasi-judicial proceeding, acting like a court by adjudicating the legal rights of parties, taking evidence, examining witnesses, and producing an appealable written decision. Quasi-judicial hearings conducted by public bodies are meetings open to the public. Still, the public body may discuss and weigh the evidence received during the hearing in private deliberations, much like a jury does, and it may collaboratively draft its written decision in a private as well. Once a written decision is finalized, that written decision stands as the body's public decision. As long as it is issued as a public record, it need not also be adopted in open meeting. An executive session is a closed portion of a public meeting. It can only be used to discuss specific topics that the Vermont legislature deemed appropriate for private discussion. To enter into executive session, a motion must be made in open session that indicates the nature of the business in the executive session, preferably naming a specific provision of open meeting law that gives that authority. For a municipal body, the motion must get a majority vote of those present in order to pass. For a state body, a 2/3 affirmative vote of those present is required. The 16 topics permissible for executive session are named in the open meeting law, Title I, Section 313. Note that 6 of these topics require the public body to additionally make a specific finding that premature general public knowledge would clearly place the public body or a person involved at a substantial disadvantage. The public body has the discretion to decide who may attend the executive session. It can invite staff, legal counsel, anyone who will be discussed or whose information is needed. Once in executive session, discussion must be limited to permissible topics and no formal action may be taken except for actions related to securing a real estate purchase option. The public body must vote to conclude an executive session. And again, this requires a majority of those present for the public bodies and 2/3 for the state bodies. Effectively, this requires the body to re-enter open session, at which time it can opt to take formal action, move on to the next agenda item, or as appropriate, end the meeting. This use of executive sessions goes against the purpose of open meetings. Public bodies should close their meetings rarely and then only for legitimate purposes. Some bodies choose to go beyond the requirements of open meeting law and do everything in public, except where other law requires confidentiality. The risks involved in letting everyone know all of a public body's business are not small. Nonetheless, there is generally no penalty for extra openness, and there is a high return on investment if the public understands you have nothing to hide.
The open meeting law isn't just about acting before the public. It's also about acting with the public. Public participation, the right to be present, the right to be heard, and to participate is another essential element of open meetings. Under the open meeting law, public bodies must give members of the public a reasonable opportunity to express opinions on matters considered by the body at an open meeting, except for during quasi-judicial hearings, because there are due process considerations. Many public bodies allow public comment at the start of the meeting, while others place it as the final agenda item. Some bodies allow public comment whenever anyone is present that has something to add to the conversation. We recommend allowing the public to comment on each item as the public body proceeds through the agenda, after the body's discussion of the item, but before any decision is made. This might be supplemented with an additional distinct public comment period at the end of the meeting. We should note here that public comment is a right, but it need not be a free-for-all. The board chair may establish reasonable rules to maintain order, and reasonable limitations on the amount of time for each speaker are not unusual or improper. You can use your rules to encourage members of the public to bring the community's concerns to your attention, to support participation by all, and to help attendees know what to expect.
After the meeting is over, a public body must ensure that its decisions are recorded and that interested members of the public are able to find out what happened at the meeting. The open meeting law requires all public bodies to keep minutes of their meetings. We'll cover the minutes requirements first and then talk about when electronic recordings of meetings are required. Minutes are the permanent record of the formal actions of the public body and play an important role in recording the history of the public body's business. Every public body is responsible for creating its own minutes of each meeting it holds. At minimum, minutes must include the names of all members who are present at the meeting, the names of all other active participants, all motions, proposals, and resolutions made, and their dispositions, and the results of all votes, with a record of individual votes if roll call is taken. Beyond this, the open meeting law requires that minutes give a true indication of the business of the meeting, covering all topics that arise. Minutes are public records and must be made available upon request after 5 calendar days from the date of the meeting. If a public body maintains or designates a website, minutes must also be posted to that website no later than 5 calendar days after the meeting. Except for draft minutes replaced with updated minutes, posted minutes must not be removed from the website sooner than 1 year, the date of the meeting for which they were taken. As an aside, we'll note here that minutes need not be taken in executive session. And if they are, minutes of an executive session are not subject to public records requests. While all public bodies must produce written minutes, not all public bodies must electronically record their meetings. Advisory bodies, whether state or local, are exempt from electronic recording requirements. Of course, advisory bodies may certainly record their meetings and post these recordings if that helps maximize access to their meetings and participation in their work. All decision-making public bodies must create and post electronic recordings. These requirements differ slightly depending on whether the decision-making body is state or local body. State public bodies must video record their meetings. These recordings must be posted online in a designated electronic location, and the original retained by the state public body for at least 30 days following the approval and posting of the official minutes for that meeting. While we recommend posting your meeting recording as soon as possible after the meeting, the state 30-day posting period would typically not start until after the body's next scheduled meeting, when the body approves the minutes for the meeting to which the recording relates. Local public bodies must electronically record their meetings or cause their meetings to be recorded, but local recordings may be audio only. These recordings must be posted online in a designated electronic location and otherwise retained by the local public body for at least 30 days following the posting of the minutes for that meeting. For local public bodies, the 30-day posting period starts when the minutes are posted online. There are some exceptions to recording requirements. If a state or local public body gathers for the purposes of a site inspection or a field visit, it need not electronically record the site inspection or field visit. And a local public body is exempt from the recording requirements, posting requirement, or both if the municipality can demonstrate undue hardship. The definition of undue hardship here is the same as for requests for alternative access. The municipality would need to prove that the recording of their meeting and or posting of those recordings would require significant difficulty or expense to the municipality, considered in light of factors such as the municipality's size, availability of staff, and its available resources, and the costs associated with compliance. The idea here is to recognize that for some very small towns in Vermont,
Meeting accessibility is still important, but technological or staffing challenges might make it difficult to always record local meetings.
What happens if a public body violates the open meeting law? Well, there can be criminal penalties, misdemeanors, and fines for knowing and intentional violations. Those penalties can accrue to a member of the public body, any person who violates the law on behalf of a public body member, or any person who participates in someone's wrongful exclusion from a meeting. More commonly, though, enforcement occurs when there is an aggrieved member of the public or the Vermont Attorney General files suit in court, asking the court to make a call about whether a violation occurred and determine the appropriate remedy. That might be a declaratory judgment, which is a binding determination on the parties, or injunctive relief, requiring the public body to do or stop doing something. Under some circumstances, the court might also hold the public body responsible for the other party's attorney's fees and litigation costs. Enforcement of the open meeting law is a two-step process. Every municipality must post on its website, if it has one, the procedures for submitting a notice of an open meeting law violation and the corresponding statute. And every public body must publicly respond if it receives notice of a violation. If a member of the public believes that a public body has violated the open meeting law, their first step is to submit written notice to the public body. The body must respond publicly within 10 calendar days, either by acknowledging the violation and stating its intent to cure, or by determining that no violation has occurred. Failure to publicly respond is treated as a denial of the violation. If the public body acknowledges a violation, it must be cured within 14 calendar days. First, the body must publicly ratify or declare as void any action that was taken at or resulted from a meeting that was improperly noticed, a meeting that a person or the public was wrongfully excluded from, or an executive session or portion of an executive session that was not authorized. Second, the body must adopt specific measures that actually prevent future violations. If the public body denies the violation or fails to make a timely cure to an acknowledged violation, the aggrieved individual may file suit against the body in civil division of the Superior Court in the county where the violation took place. The suit must be brought within 1 year after the relevant meeting. The court will then decide whether an actual violation occurred, what relief is appropriate, and whether the circumstances require the public body to pay the other party's attorney's fees and litigation costs. Of course, it generally does not need to come to this. As we mentioned earlier, the spirit of the law is all about how transparency yields trust. There are guardrails to prevent willful disregard of the open meeting law, but the whole point here is that by removing barriers between you and the public, you are creating conditions to be proactive rather than reactive.
You may be watching this right now because the open meeting law requires it. Annual open meeting law training is mandatory. Chairs of state decision-making bodies, chairs of local legislative bodies, town managers, mayors, and members of any state advisory body that is composed entirely of non-government volunteers. Whether you are complying with the law or simply want to learn more, who knows? Participating in trainings on open government and accessibility topics is one way to engage and be proactive about building trust in government.
Thanks for taking the time to view this training video, and thank you for your work to support the vibrancy and health of Vermont's civic life. Serving on a public body is a considerable commitment. The actions that public bodies take impact Vermonters' lives every day. Decisions about how a town's funds are spent, how a road is managed, the school bus schedule, how land is zoned, how a profession is regulated, or how a town library is accessed and managed matters to Vermonters. Ultimately, if members of the public understand those decisions, even if they don't agree with them, the community will embrace those decisions that have been made. Open meetings help build trust in government and the democratic process. Now, more than ever, Vermonters are relying on your willingness to engage in respectful conversations, your integrity when making tough decisions, and your commitment to open and accessible government.
If you have questions for us about the open meeting law, You can contact us. Reach out to us by phone, email, or via our website. For records related questions, our state archive specialists are also ready to help.
Right? It would be
Yeah.
Like sound normal and all of a sudden it gets
Right.
loud. And
Very weird.
then, I guess that's our internet.
Hmm?
I guess that's our internet.
I don't know.
I think it's
it's
the video.
I
recording.
watched this before and it wasn't like that. I don't think.
I watched it
Right?
on my
Recently.
phone. I maybe just because it was like smaller, I didn't notice it as much.
That was loud.
Any questions or comments on the training?
Very, it was good.
Yeah.
Very good.
Gotta watch it again.
Easy to find. Tell you that.
Do I have any questions or?
No.
No.
We'll adjourn meeting of the training.
Right.